in itself in the question of law is a preliminary objection on the question of law. Once that question is determined, I'll pack to leave to Nyamira, or I'll continue with the submission. Because if a question of law has been raised, a preliminary objection of law that these proceedings, there is no jurisdiction to entertain this matter. Because the matters are active in a court of law. Do we reconstitute ourselves and close our ears and close our eyes and see a good case you have against the governor being thrown out at technicalities? Reconsider and let the matters be determined, that those matters that are in the High Court, let those matters in the magistrates' courts be determined, let those matters in the Court of Appeal be determined, bring a proper motion, remove your governor, because that is your right. It cannot be taken away by anybody. It is protected by 55 million Kenyans who passed the Constitution on the 27th of August 2010. It goes further and says in paragraph 5, notwithstanding the standing order, the Speaker may allow reference to a matter before the House or a committee. The Speaker can only have a reference or a citation. So the question I'm pushing ahead, and my colleagues are pushing, is how did this motion of impeachment pass the threshold for it to be in the order paper as a subject of discussion? It was an error, and we simply agree that that error is not fatal. We stop this matter until when the law allows you to remove the governor. It is your right. I'm telling you, it is your right. Some of the matters my good friend Mutuma will raise are filed by the assembly. Can we move one step further? Second question. The question about public participation. A report has been tabled. A report has been tabled. When you look at the standing order 68, look at it. Standing order 68. It says the accused person needs to be given at least, and it is shall, 2 hours to read, to update herself, to instruct his counsels on what to answer. That report is only known to others, not to the person accused person. Is that the order that we need to be given that report? Look at it, at least 2 hours. We take instructions from the governor. We respond appropriately. Third issue on question of law. What does the law say on where public participation is supposed to be done? Is it in the sub-counties or is it in wards? any elected or nominated member of the county assembly representing a sub-county. As we are here, all of you represent wards. Public participation is ward-based. It is not administratively based on the national government. It is an election-generated mechanism that allows people as constituted in the elective positions, elective places, they make decisions based on the wards. By identification of them being voters in that ward, being beneficiaries of government services from the county government of Embu, of Meru, to those wards. There is no national member of parliament here who represents a constituency. And that is why we are saying we needed to have that report and tell it that it is not proper. The public participation, if ever it was done on a wrong path, on a wrong locality. Lastly, on a question of law still, who was the public participation targeting? Look at the summons. The summons are in regard to a person called Notice of Motion for the Removal of the Governor Meru County, Honorable Bishop Kawira Faith Mwangaza. Who is that person? When my brother stands and gives you the documents of the true name of your governor, you were present. You were present when she was being sworn in by the judiciary. There was nobody sworn in by the judiciary called Bishop Kawira Faith Mwangaza. We have the judiciary certificate here. It is public knowledge. You have the deed poll that was sworn way back in 2012. Change of names. Public participation was done for a stranger. My full names are Danstone Omari Mugak. If you do public participation for Evans Omari Danstone, that is not the governor. Are we properly here with the right person being the subject of this investigation? Those are 4 critical legal questions that I have very firm instructions to seek a ruling from the Speaker, whether technically and legally we are properly constituted and ready to do business of the removal and defending the removal or defense of a stranger. Honestly, we cannot impeach a stranger called Frida. We can't. That Frida has never taken an oath of office as the governor of Meru. That public participation was targeting a stranger, total stranger. And that is why the standing orders cannot allow me to sit there. I'm a stranger. You have reserved these for strangers. How do you discuss a stranger? Those 4 points, I'll allow Mutuma to reinforce them. Mwenda, on those issues of law only, Mwenda can produce the documents so that the Speaker gives a ruling.